All right, I will call this meeting of the Senate Judiciary Committee to order. Would the Secretary please take the roll?
Senator Harris, Senator Orenshaw, Senator Dondero Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you so much. Please mark those senators present when they arrive, if they're not already here. We have two bills up on our agenda for this afternoon. We will start with AB 126, and I will go ahead and open up the hearing now.
Thank you very much. Good afternoon, Chair Scheibel, Vice Chair Harris, and member of the distinguished, amazing, and awesome Senate Committee on Judiciary. I have that on my notes. I am Assemblyman Yui Nguyen, and I proudly represent District 8 in Southwest Las Vegas. I am thrilled to present Assembly Bill 126 to you all today, as this is the first bill I ever introduced of my legislative career, which is 4 months old. And I'm gratified that it made it all the way here. This is also a particularly special bill because, as you may heard, this has been referred to as a win-win. Thank you. Thanks to my joint bill co-sponsor and colleague sitting on this committee, Senator Rochelle Nguyen. She co-presented with this bill with me during its assembly hearing, and I'm grateful to be presented today before you. When the business law section approached me about carrying this piece of legislation, Senator Nguyen and I both agreed on one condition. They had to walk you through the bill because this is a technical one. That is what we call a win-win situation. Less talk from me and more from them, the experts. Jokes aside, it's important work by the business law section to keep Nevada business statute current and competitive. We appreciate the diligence by the section to ensure Nevada is keeping pace with other states. You will note several of the bill section proposed concept that already exists in state like Delaware, which is often referred to as holding the gold standard in corporate law, and we want to make Nevada competitive, and AB 126 help us get closer to that goal. For example, AB 126 proposes efficiencies such as permitting a board of directors to change the name of the corporation without requiring the vote of stockholders. That will make doing business in Nevada a bit easier. For today's presentation, I'm joined in person by Mr. Robert Kim, chair of the section, who will walk you through the finer details of the bill. And we're also joined down south at Grant Sawyer by Ms. Mackenzie Warren. She's already at the table with McDonald Carano, who will provide additional background. I will hand it over to them and leave this in their capable hands. And Madam Chair, with your permission, I'd like to be excused to go to my other bill hearing happening at the same time in Senate Revenue. So with that, Madam Chair, Vice Chair, and members of the committee, I hand it over to Mr. Kim. Thank you so much for your patience.
Thank you for joining us. You are excused, but we appreciate you coming down to introduce the bill, and we look forward to hearing from Mr. Kim and Ms. Warren Kay. But we do need you to turn off your microphone, Ms. Warren Kay, because it's echoing. Thank you.
Chair, I think, with your permission, I think it makes sense for me to start and hand it over to Mr. Kim. Mackenzie Warren Kay with McDonald Carano on behalf of the business law section. Thank you, Chair Scheibel and Vice Chair Harris, for hearing AB 126. We've got the wrong last names for this presentation, but bear with us. Just a brief background for the committee about the business law section. They're comprised of attorneys from all over the state, business lawyers and transactional attorneys that are interfacing with Nevada's business statutes. They see how they're working, they find opportunities for efficiencies, and they also do some routine maintenance to make sure that Nevada is keeping pace with the trends, and we look to other states to understand what practices they may be adopted to keep Nevada as the preeminent place to do business and as a top business-friendly state in the country. So with that, we do have a memo that outlines the bill section by section, and our technical expert in the hot seat with you this afternoon is Mr. Rob Kim. I will kick it over to Mr. Kim. Thank you.
Good afternoon. Robert Kim, a partner at the law firm of Ballard Spahr, and here in my capacity as chair of the Executive Committee of the Business Law section of the State Bar of Nevada. I'm here before you, as described before to you, on behalf of the Business Law section and presenting to you Assembly Bill 126. And a little background as to the bill and as to the process involved. And after that, I will go through a summary of the key provisions of the bill, and obviously welcome to answer any questions you might have. The bill before you is a product of generally 2 years' work between sessions, where we collect recommendations, suggestions, and we kind of follow different trends in corporate jurisprudence throughout different markets throughout our country, and we try to compile them in an orderly fashion in our bill, and try to present items that we think are appropriate for Nevada. We vet them through our committee. The process then requires us to submit the bill to the different section leaders of the State Bar of Nevada and the State Bar's Board of Governors for their approval to submit that to the legislature. As I put a clarification, our submission of the bill and our advocacy on behalf of AB 126 has been authorized by the State Bar of Nevada, but is not meant to indicate their opinion or their position on any of the subject matter contained therein. They make it very clear that their authorization, their approval, is to allow us to advocate on behalf of the bill. So with that background in mind, I will just go ahead and go into the key items of the bill. And if there's anything that I have not described, I'm happy to go back and address those as well. But I'll just cover the key aspects of it. The first section of our memorandum covers about 10 sections, and there is just a point of clarification as to how corrections to filings can be made in the state of Nevada. We had adopted these statutes quite a while ago to allow different business owners to file corrections if there's a typo or some kind of, if the wrong language was used, to file a certificate of correction, identifying that error, and then obviously presenting the appropriate language. What we wanted to do is not only allow or clarify that not only can you correct the language in a filing, but you could actually correct the filing itself if the filing itself was filed incorrectly. And this is a practice that the Nevada Secretary of State has already been adopting anyway, accepting different filings in lieu of the incorrectly filed one. So we just wanted to make that correction in every statute. And the Nevada Secretary of State's office is on board with that as well. The next section I wanted to clarify relates to sections 4, 9, 10, and 14 of AB 126, and they deal with NRS 78195, 350, 378, and 433. And these relate to the ability of the Board of Directors to adopt plans, arrangements, or instruments on behalf of its stockholders. And there we just wanted to clarify that the broad power given to the board should be used in conjunction with a series of preferred stock, so that they grant the rights to the preferred stock, and then they attach to the shares, and then those are distributed to the stockholders for purposes of implementing the plan, arrangement, or instrument. The next item is Section 5 of AB 126, and this is a new concept that we wanted to introduce. It relates to reverse stock splits, and reverse stock splits are when a corporation takes its issued and outstanding shares and reduces them by a factor of 2, 3, 4, 10, whatever the board may determine. So if a corporation had 100,000 shares issued and outstanding and did a reverse stock split of 1 for 2, then the shares would go from 100,000 down to 50,000. Generally speaking, those reverse stock splits require the board approval and the approval of the stockholders to go ahead and get that done. But given today's nature and today's widely held nature of public company stock, and the fact that most stockholders, retail stockholders like me, like you, like most people that we know, don't really respond very well to proxy solicitors that want to get us to check those boxes and mail back those ballots. We thought it was appropriate to allow a corporation to have these reverse stock splits authorized by an approval of the stockholders, not by a majority vote, but by as long as the votes cast in favor of it exceeds the votes against it. So that will make this approval process a lot simpler and a lot more realistic to obtain There's been many instances where public companies are not able to secure a majority of the voting power, and their ability to proceed with the company, raise capital, has been frustrated by that inability. And this ability to amend, and this amendment only relates to public companies as well. The next item I would want to highlight relates to item Section 8 of AB 126 and relates to the right of inspection. Stockholders of record have certain inspection rights of the company's books and records, and in doing so, there's a process in the statute. What we are looking to do is twofold. One is to codify a common practice, which is where the company asks the stockholder to agree to maintain such books and records on a confidential basis, because it's in the best interest of the company and the stockholders to not have confidential information about the company made public. And it's usually a result of the back and forth that goes on between a corporation and its stockholders when this request is made. And secondly, we also want to eliminate the liability of the officer or agent of the corporation, the personal liability of the agent or officer of the corporation for violations of the statute, because we didn't think it was appropriate that a person that merely is holding the books and records on behalf of the corporation have individual exposure in that regard. The next item I wanted to talk about was Section 12 of AB 126, and it relates to the ability of a board of directors to amend the name of the corporation. Because the name of the corporation is in the Articles of Incorporation itself, our statute requires any such amendments to the Articles of Incorporation to be approved by the board and then approved by a majority of the voting power. As noted before, at times it's very challenging to obtain a majority of the voting power. It takes time, and for public companies, it takes money. It could take 3 to 6 months. It could take thousands of dollars to try to find enough votes to obtain a majority of the voting power. So in this instance, we thought we would follow some other states that have allowed a board of directors using their fiduciary duties to, on their own, make the decision to amend the company's name and change it without the vote of the stockholders. This is a concept that already exists in Delaware, and it exists in about 10 other states. And it's something that, as practitioners, we've been asked about a lot over the years. And we thought, as a committee, we had received enough feedback to bring this recommendation or this amendment to the legislature. And then the last item I think worth noting relates to sections 28, 25, 26, 30, 27, 25, and 31. And I just want to make sure that the purpose of those amendments, although they are numerous in section and impact, they merely only take 2 sections of defined terms and move them from the beginning of Chapter 92A to the dissenter's rights section of Chapter 92A, which is sections 300 to 500. And the reason why we're moving those 2 sections from the beginning of the chapter to the end is because a corporation, in the context of dissenter's rights, is required to send a copy of the dissenter's rights to all the stockholders. And it made a lot of sense to make sure all the relevant sections that relate to the dissenter's rights are within the same range of sections, instead of having 2 section outliers in the beginning of the chapter. That would make delivery of the statute just a little more difficult and inconvenient. So just want to clarify that we did not make any changes to the text, but just merely moved the sections to 92A 300 to 500, and those numbers will be assigned by the LCB to the extent that this is approved. So those are the items I wanted to highlight, and if there are any questions, I'm happy to answer them at this point.
All right, thank you. Members of the committee, Senator Orenshaw.
Thank you, Chair. And not really a question, if it's okay with your indulgence, just a comment. Mr. Kim, I just want to thank you for your dedication to this area of the law. And I know it's an incredible personal sacrifice chairing the section and the work you do. I had the opportunity to work with Kim during the last, Mr. Kim, during the last interim on a similar bill. And I appreciate all you do. Just thank you, Chair. I want to make that comment.
Thank you. Other members? Senator Stone.
Thank you, Madam Chair, and thank you, Mr. Kim, for the presentation, and I appreciate actually meeting with you earlier today. anything we can do to make Nevada more business-friendly is certainly something that I want to get behind. But I want to ask you just a question about Section 5 when you talked about the reverse stock splits. Basically, you're saying that you didn't need a majority of all the shareholders. You just needed the shareholders that responded, a majority of them, in order to effectuate that change. So, but what is the effort that the board does to reach all stockholders? Do they send them all a letter? Do they send them all an email? In other words, is there some attempt to reach all shareholders by a specific time before they say, okay, we've had those that have responded, we're going to take a majority of those, and we're going to move forward?
Robert Kim, here on behalf of the State Bar of Nevada. Thank you, Senator Snow, for that question. And just to give greater context and understanding, this amendment that's contained in Section 5 of AB 126 relates only to publicly traded corporations. So in that context, if there is a desire to have an adverse stock split approved by the stockholders, a publicly traded corporation is required by securities laws to notice a meeting and to send a proxy statement soliciting the vote of all the stockholders, where that proxy statement has the background, the material information needed for the stockholders to understand what is being asked of them and what the vote is being required of them to have this item approved. And so every stockholder would receive a copy of the proxy statement, whether directly by virtue of the fact that they are record stockholders or through their broker-dealer by virtue of the fact that they are street holders of the common stock. And they would have the opportunity to review review the matter asked of them and vote on it. And where I mentioned before, where there is a big drop-off is the conversion rate of actual votes that record stockholders, that street stockholders, street name holders, typically is very low. And that's why we're proposing this, because it's hard to really get all those votes to actually accumulate the majority of the voting power to have items like this approved. So as you noted, the standard we are requesting is that a majority of the votes cast in favor would be sufficient to approve of a reverse stock split, which is the same standard that exists for approval of directors in Nevada as well.
If I can just follow up one time, is it safe to assume that if you had a 2-to-1 buyback, that obviously you're going to have less stock, correct? So is it fair to assume that that stock would have double its value? This is not going to effectuate the collective value of the stock portfolio that you have in this particular company by having a reverse stock split.
Robert Kim, State Bar, Nevada. So the question is, what would be the impact of the stock price if one did a stock split? And obviously, markets are what they are. They may be efficient, they might not be efficient, but theoretically, I think you are correct. If I do reverse stock split by a factor of 2, and those 100,000 shares that I mentioned before become 50,000 shares, if that stock price before was $1 a share, then that stock price afterwards should be $2, theoretically, if the markets were efficient.
Thank you.
Vice Chair Harris.
Thank you, Chair Scheibel. My question is also on Section 5. So from what I've heard in the discussion, the goal is to ensure that you just need a majority of the votes cast. So why not have the language just say that, as opposed to regardless of limitations or restrictions on the voting power of the affected class? It seems to me it should say proposals approved by the stakeholders of the affected class or series if a majority of the votes cast are in favor, or something similar to that effect, right? I think the language that we have before us is a bit more broader than what I'm hearing your stated goal is.
Robert Kim, State Bar, Nevada. Thank you, Vice Chair Harris, for your question. The reason why it's written this way is that is because a corporation might elect to choose a different standard, and what we're allowing them to do is to state the standard that they want to in their bylaws or in their articles of incorporation. So I guess I was too quick to state what the standard was that I would expect companies to use, which is a more votes cast in favor than against, but a corporation could like to choose a different standard as well. And so what we were doing there with that language was to provide that flexibility to change the standard, and then for the corporation to adopt the right standard that they thought was appropriate for this.
So can you give me some examples of maybe other standards that might come up?
Other standard, Robert Kim again, State Bar of Nevada. Other standards that might come up, it could be something that they could require a certain percentage of the outstanding shares instead of they could ask for a certain flat percentage of the shares. It could be a combination if they wanted to. If they wanted to make sure, for example, yes, more shares voted in favor of it than against, but yet they wanted to couple it with at least having a third of the shares that are outstanding vote for it, then they could do that as well, just to make sure there were enough shares out there instead of, for example, 2 shares showing up, outvoting 1 share, for example. So there are other ways, that there are certain combinations that they could use, and so we wanted to just be able to be mindful of that and allow for that as well.
One more, if I may, Chair. Thank you. Am I correct in understanding, though, that the way the language is drafted, the company could in fact choose to allow 2 shares to outvote 1 share, if that's the standard that they chose?
Robert Kim against State Bar of Nevada. I don't think one would actually be able to state that as a standard. That might be the actual result of the shares tendered. There were only 3 shares that showed up to the vote, but and when we deal with public companies, my experience is usually that there's shares outstanding in the thousands, with companies that have hundreds of millions of shares outstanding. So I don't think there would be a situation where there would be 2 shares outvoting 1, but the problem is that there's a very low turnout, and so this is designed to address that low turnout and to not basically keep a publicly traded corporation in limbo. And because I've had situations where a corporation has had to call a meeting 3 years in a row without the ability to secure a majority of the voting power to be able to either increase capital or gain additional flexibility. And so that really puts management's ability to raise capital and conduct the company operations, it really hampers them.
So I guess my one small concern is that we're going from the standard of you have to have a majority to there's a standard that you get to pick. And I would personally feel much more comfortable figuring out what that standard should be. A majority of the votes cast sounds great to me, with a minimum of 35% participation, or whatever number that, you as the informed expert in the area might find to be suitable. We're going from one end, I think, where we have a standard that's unfair, to you can kind of choose your own adventure a little bit, and I'd rather us land on something that's more reasonable than a majority of the outstanding shares if that doesn't work, if that makes sense.
Robert Kim, State Bar, Nevada. I understand your concern, Vice Chair Harris. At a minimum, though, it definitely would not be a situation where you'd have a minority of the votes that were in favor of something outvoting a majority of votes that definitely didn't want it. So in this instance, it definitely is a case where, as long as there are more votes cast in favor of the amendment versus votes cast against it, it would be approved. So there's definitely that floor, I suppose, to describe what you mean.
Yeah, but that's not what the bill says. That's what I'm getting at. That the bill doesn't actually require that be the resolution. It says regardless of any limitations or restrictions on voting power. And so it seems to me it doesn't necessitate that. And if we want to necessitate that be the standard, we probably have to say so.
Robert Kim, I understand your point. So I'll have to take a look and see if there's another way to restate that. But I'm not concerned that would be interpreted any differently. But I understand where you're coming. I understand your point.
Other questions from members of the committee? Yeah, Senator Krasner.
Thank you, Chair. Thank you for your presentation. I just had a quick question about Section 8, Sub 5. So it says that if any officer or agent of the corporation keeping the books of account and the financial statements knowingly and willfully refuses to permit an inspection of the books of account and financial statements upon demand by a person entitled to inspect them, or knowingly and willfully refuses to permit an audit of such books of account and financial statements to be conducted by a person, they are no longer liable for anything. They can refuse. So I'm guessing, first of all, they could refuse a shareholder who normally has the right to come in and inspect books and records with notice, and law enforcement as well, or anybody that's from the government, any government official from an agency that has the right to inspect books and records. So an officer could just say, I'm going to hold these back. I'm not going to let you look at them. I don't care if you're a shareholder, a member of an agency of government, and then they're no longer liable for anything. I mean, they're off the hook. It's just the corporation, according to the amendment. Is that right?
Robert Kim again, State Bar, Nevada. I understand your question. Let me just maybe re-clarify the intent and purpose. One, as it relates to law enforcement, this statute only relates to the relationship between a corporation and a stockholder. So obviously, law enforcement has the ability to, within the scope of presumably its warrant, to obtain any records, and this statute would have absolutely no bearing on their ability to review that. The reason why we thought it was appropriate was that this doesn't absolve the corporation from any penalty at all. What it does is it prevents a clerk in the corporate offices who's being told to do something to be named personally for following orders of the corporation. It's the only situation where there's an individual liability in the statute versus that doesn't relate to an officer and director. So we thought it was
It actually does say officer. In Section 8, Sub 5, it does say officer or agent. So was it your intent to make it only agent? Because generally an officer or director of a corporation has a fiduciary responsibility to the shareholders, I believe.
Robert Kim again. The fiduciary duties of officers and directors go to the corporation as a whole, and which obviously the stockholders are constituents of, and the individual liability of an officer and director is already addressed in NRS 78-138, subsection 8, and so we thought it was not appropriate for this section to have its own liability standard when one already existed for officers in section 78-138, subsection 8, and again. The point was, if an officer is breaching their duties, and they're doing so with knowing violation of law, fraud, or intentional misconduct, then that individual liability already exists.
But this would be in conflict with that then, I believe, Section 8, Sub 5, because it does say if any officer or agent of the corporation. So if an officer knowingly and intentionally does not let a shareholder inspect the books, there's no penalty then, right? And that would be in direct conflict with your other law, with existing law that says officers and directors do have a fiduciary responsibility to shareholders, correct? So which law would apply?
Robert Kim, State Bar, Nevada. So the intent was not to somehow undermine the duties of an officer in general. Those duties exist, and they're stated in NRS 78-138 as being owed to the corporation, and like I said before, the stockholders as well. The point here was that there's an individual liability standard that is kind of inconsistent with the way we treat that standard in Chapter 78. So we thought it was appropriate just to leave it in the context of NRS 138 in terms of individual liability.
your first statement was this only applies to agents of the corporation. So was that really your intent, or was it your intent that it applies to officers and agents of the corporation?
It would apply to officers and agents. The scope of this section, those that are, literally at the corporate offices trying to follow directions of, I guess, the board of directors or some other CEO or other C-level officer, presumably.
Okay, but it does say officer of the corporation.
Robert Kim again, State Bar of Nevada. No, yes, I'm not. This is meant to take the liability standard for the scope of persons in this section and eliminate the liability standards. So we're not trying to absolve the corporation from any wrongdoing. If the company's denying these rights, they could be taken to court for that. But the liability standard, we thought, was just not consistent with the statute overall.
Okay, so what would be the liability standard if an officer intentionally and willfully denies a shareholder to examine the books?
Well, the officer or agent would be taking action on behalf of the corporation, and then if there was an issue with that, then the stockholder presumably file a lawsuit against the corporation.
This would absolve the officer from taking those acts willfully and intentionally and not letting the shareholder examine books, and the shareholder's remedy would only be to sue the corporation, not the individual officer. Is that correct?
Robert Kim, State Bar, Nevada. I would say that's not correct. We're not trying to absolve any individual. We're just trying to clarify that the individual liability standard already exists in Chapter 78, 138. So if a director or officer breached their fiduciary duty and did so in a manner that was willful, knowing violation of law, or involved fraud, then that's how they would be individually liable, and they could be sued in that capacity for breaching that fiduciary duty and engaging in that conduct.
Okay, I appreciate that. It just, the way it's written here, it does say in Section 8.5, officer or agent. So.
All right, any other questions from members of the committee? All right, I don't see any other questions, so thank you both for your presentation, answering all of our questions. We'll move now to testimony in support of AB 126. Anybody wishing to give support testimony in person is invited up to the table in front. And I'll give Mr. Kim a minute to step back to the front row of seats, and you can begin whenever you're ready.
Good afternoon, Chair, members of the committee. Paul Murray, acting with the Vegas Chamber. The Chamber first would like to thank the bill sponsor for bringing the bill forward. We are in support of AB 126, as this bill will bring additional efficiencies for our Nevada businesses, which is important to operations on their behalf. And also, as you've heard, this bill will also allow us to stay competitive on the national perspective with states such as Delaware. So thank you very much, Chair and members of the committee.
Thank you. I don't see anybody else coming forward to give in-person support testimony on AB 126, so we'll go to the phones for support testimony on AB 126.
If you would like to testify in support of AB 126, please press star 9 to take your place in the queue. Good afternoon, Chair Scheibel and Vice Chair Harris, and members of the Senate Judiciary Committee. My name is Peter Guzman, President of the Latin Chamber of Commerce, and it's my pleasure to testify in support of AB 126. We thank the Business Law section for including the Latin Chamber each session and keeping our members, our very important members, current on how Nevada is taking positive steps forward to protect its reputation as an excellent place to conduct business. I also want to acknowledge the bill sponsors, Senator Wynn and Assemblyman Wynn, for taking on a very complicated but important topic to our business community. This bill provides additional clarity to our business statutes, and nothing is more critical than having predictability when making business decisions. sometimes those decisions need to be made quickly. AB 126 is a pro-business piece of legislation, and the Latin Chamber, who always stands with the business community, urges your support on this bill. Thank you.
Caller with the last three digits, 477. You are clear to unmute.
Good afternoon, Chair Scheibel and Vice Chair Harris, and members of the Senate Judiciary Committee. My name is Jen Bambao, and I am the Vice President of AAPI Chamber of Commerce. We want to thank the Business Law Section and the bill sponsors, Assemblyman Nguyen and Senator Nguyen, for their work on this bill. We support Assembly Bill 126 because it helps to maintain Nevada's position as one of the most pro-business states in the nation. As leaders in our business community, it's critical that we are involved in the legislation that impacts members. But even more importantly, it's critical that Nevada's business statutes provide clarity and stay competitive with other states, so that Nevada remains a top destination to incorporate and conduct business. AB 126 brings better predictability and provides efficiencies for Nevada companies, which is central to our organization's mission. We thank Senator Nguyen and Assemblyman Nguyen for their work on the bill and the section for including us in this process. Our organization would urge your support on AB 126. Thank you.
Chair, we have no further callers testifying in support at this time.
All right, then we will take testimony in opposition to AB 126 in person. I don't see anybody coming up to the table in Carson City or Las Vegas, so we'll go to the phones.
If you would like to testify in opposition for AB 126, please press *9 to take your place in the queue. Chair, we have no callers to testify in opposition at this time.
All right, then we will go to neutral testimony on AB 126. Anybody wishing to give neutral testimony in person is invited to do so now. And again, I don't see anybody coming to the tables in Las Vegas or Carson City, so we'll go to the phones for neutral testimony on AB 126.
If you would like to testify in neutral for AB 126, please press *9 to take your place in the queue. We have no further callers to testify in neutral.
All right, then I think that brings us to the conclusion of testimony. Any closing remarks from our sponsors? It's entirely optional. But please, come on up.
Thank you. Robert Kim against State Bar, Nevada, and this middle chair does sit quite lower than the other ones. Just to address the concerns raised by Vice Chair Hansen, I just want to merely state plainly just what the statute is meant, what our language is, and obviously with their concerns, we're happy to discuss them further. But again, for Section 5, the ability for the reverse stock split approval, it does require the approval of the stockholders, which it must be more than the votes cast against it, and also in this context for a publicly traded corporation, as I described before. The process would require mailings and notices to all stockholders because it is a publicly traded company subject to securities laws of the 1934 Act, which requires timing, notification, disclosures to be materially accurate, and obviously solicitation to be made. So just wanted to just provide that quick statement just to clarify that this ability that we're looking for is just limited to publicly traded companies, and it does require approval of stockholders, just in case there's any confusion that there might not be, or there might be some other way that this could be possibly be abused or anything like that. So just wanted to state that for the record. Thank you very much.
Thank you so much for clarifying. And that brings us to the conclusion of our hearing on AB 126. I'll now close the hearing and open up the hearing on AB 405. I understand we have Judge Wood with us on Zoom.
Hello.
There we go. All right, go ahead whenever you're ready.
Thank you very much. I'd like to start by thanking you, Chair Scheibel and Vice Chair Harris, and thank the Senate Judiciary Committee for allowing me to present today. I am going to share my screen. Bear with me. So, the goal of AB 405 is to expand mental health treatment here in Nevada. The purpose of this bill specifically is to do two things. First, to clarify that Justice Court has jurisdiction to establish a mental health court program. And second, to clarify that mental health courts have the authority to impose intermediary sanctions during the mental health court process, including incarceration as an intermediary sanction consistent with clinical recommendations. So I want to discuss just very briefly the state of mental health and our criminal justice system here in the state of Nevada. As of 2018, the Clark County Detention Center was the largest mental health facility in the state of Nevada. A nationwide survey published in 2010 found that the odds of a seriously mentally ill person in Nevada being incarcerated versus being in a psychiatric hospital was 9.8 to 1. So a mentally ill person in Nevada is 9.8 times more likely to be incarcerated in our state than to be in a psychiatric facility receiving mental health treatment. And the cost of not treating mental health to our state is recently in 2021, Clark County spent $286,998,563 to incarcerate 2,854 individuals. Approximately 20% of the inmate population at the Clark County Detention Center is estimated to be medicated for mental health issues. So that brings us back to our current statute. Currently, NRS 176A.250 allows the court to establish a mental health court program. However, NRS 176.030 defines court as the district court. So while NRS 176A.250 does reference NRS 174.032, which would allow justice courts to establish programs, what we're seeing is it appears that it was the intent of the legislature to allow justice courts to establish mental health court. However, as the statute is currently written, it could be open to interpretation and potentially not give jurisdiction to justice courts to establish mental health court programs. So currently the Las Vegas Justice Court, which is the largest justice court in the state of Nevada with 16 justices of the peace, is seeking to create a mental health court. Before moving forward with the creation of a mental health court, which is going to be costly and going to require a lot of resources, we want cleanup language because we want to clarify that we have jurisdiction to create such a court. It is our position that we do have jurisdiction, but we don't want to go forward and start the court, obtain the grant money, use all the resources, and then partway through be told that we don't have jurisdiction. That would be very costly and a waste of resources. And so we want to make sure on the front end that we have our jurisdiction and have that cleanup language to clarify that we have jurisdiction. So the reason we need a mental health court. Currently, individuals who commit more serious crimes can enter a district court mental health court. And district court does have the jurisdiction to accept justice court applicants, but every justice court applicant that the district court accepts is one less position for district court applicants. So basically, the district court is where more serious crimes go. Justice court is where misdemeanors have original jurisdiction, and or all jurisdiction for misdemeanors lies in justice court, and then original jurisdiction for more serious offenses, but they go up to the district court. So essentially, every justice court applicant that would take a district court seat, it's an individual who's committed a less serious crime taking the place of an individual who's committed a more serious crime. It basically would reduce the ability to treat individuals with mental illness who are acting out more seriously. Justice Court has determined that based on our size and population, the need exists for our own lower court mental health court. The goal is to treat individuals who are committing misdemeanor crimes before they escalate to committing felony crimes. The proposed language is actually language that this legislature has already used. In 2017, the legislature amended NRS 176A.280 to clarify that district court, justice court, and municipal court all have the jurisdiction to establish veterans treatment courts. We're seeking the same clarification here, and we're using the same language. And then I do want to briefly address the sanction language as well. Due to the challenges that individuals with drug, alcohol, and mental health disorders face, the National Association of Drug Court Professionals recommends intermediary sanctions for minor violations of court rules prior to escalation determination from court programs. This mirrors the probation statutes that this legislature has established. We have intermediary sanctions for more minor violations, and then those sanctions gradually escalate and eventually result in termination if the individual keeps violating. But the recommendation is that you shouldn't violate an individual on a first minor violation. You want to keep working with them with escalating intermediary sanctions. So this provision of the statute would clarify that the court may impose intermediary sanctions, including incarceration as a sanction, consistent with the evidence-based guidelines that we have. And finally, I just want to address the fiscal impact. This bill is not requesting any funding. The Justice Court is not requesting any funding. This is purely a bill to clarify the current statutory language about our ability. We are seeking independent grants, and we will be funding this through those grants. We're not asking for any, we're not trying to have a fiscal impact. We are trying to, in fact, do the opposite. The goal is to reduce the cost of incarceration through treatment of mentally ill individuals and overall save the state of Nevada and County of Clark money. And with that, that is the end of my presentation.
All right. Do members of the committee have any questions? Senator Wynn.
Thank you, Judge Wood, for that presentation. I have a question with regards to Section 3, subsection 5, upon violation of a term or condition. I see that this is all new language. Is this language that all of the specialty courts felt like was needed to be included in here to give some clarification? Like, can you kind of explain?
But I can go take a look and clarify that. But the language is consistent with the guidelines established by the National Association of Drug Court Professionals. And it might seem strange that we're going off of the drug court professionals, given that this is a mental health court, but actually drug court is kind of the base model for all of our specialty courts. So every specialty court is based off of the drug court model. So the National Association of Drug Court Professionals is the guidelines that every specialty court uses and builds off of in building their courts. And so this is what is recommended by that association. This is evidence-based best practices. And that's where that language is coming from.
Yes, I'm familiar with the organization, so I'm glad to see that we are using some of those best practices. I know they are constantly renewing those and figuring out what follows the science, as far as treatment goes for many of these specialty courts. I guess I have a question with that subsection, or section 5, subsection A, subsection 2. It's my understanding in my work with the specialty courts that they do have the ability to impose, I guess, contempt time for violations. Did you just want to codify that in statute because that's a best practice, or what was the purpose of doing that?
Yes, that is correct. So currently, this is actually already occurring. This is all clarifying language. This entire bill is clarifying language. Currently, our district court, mental health court, is doing precisely that. They have the ability to do up to 25 days. It's via contempt time or their general district court powers. So we're just codifying that and making it clear that it is consistent with the guidelines and that jurisdiction does exist because it's currently being essentially occurring via other mechanisms. We just wanted to codify it.
Would you consider a further clarifying language that it isn't just contempt time, that time is credited towards any potential sentence that the person ultimately has imposed if they are not successful with the program? Because I'm worried that people will serve time being incarcerated as a part of the program. And unfortunately, if they are not able to be successful in that program, that they would serve their sentence either in the, jail or, in the prison and not receive that credit.
So our reading of the statute as it's currently written is because it's not being called contempt time anymore. And I think that's a problem that potentially existed before, but because it's not calling it contempt time here in the statute, I don't think that there would be any grounds to believe that this was contempt time as opposed to part of a suspended sentence that's just being imposed in increments as an intermediary sanction.
So that would just be further clarifying language.
Yes.
Okay.
That would be further clarifying language. If it's something that the committee needed, we could certainly talk to our community stakeholders. And I guess I did forget to mention that, and I did just want to also thank all of our community stakeholders. We had a lot of stakeholders that were involved in the drafting of this, and there were some amendments, and I really appreciate all of our community partners who worked together to make sure that we had a bill that addressed everyone's concerns. And so if that is an additional concern, then we certainly want to talk to all the community stakeholders and make sure that that language worked for everybody.
Your explanation makes sense, so I don't know if that's necessary, at least not on my part. Thank you. Thank you, Chair.
Thank you.
All right, other questions? Senator Orenshaw.
Thank you very much. Pleasure to see you, Judge Wood. Thank you for your work on this bill. I guess my question is sort of, I'm just wondering, in terms of the folks you see who get arrested who might benefit from this program, do you think that if Justice Court is able to establish a mental health court, you're going to see less recidivism and folks potentially not coming through that? We talk about that revolving door up here a lot. I just wonder how you see this helping some of the folks you see before your court, Judge.
Absolutely. We anticipate that it will dramatically help reduce recidivism. Our specialty courts have, the statistics are there. Individuals who go through specialty courts have significantly lower rates of recidivism than individuals who do not. Particularly, mental health is an issue that we see when individuals are arrested, incarcerated for 30, 60, 90 days, which is what's happening on misdemeanors in justice court, and then released without any sort of resources or treatment. They're going right back to the same circumstances they were in without that mental health treatment, and they're just reoffending, and we see the same individuals cycling through the system, as opposed to when we get them the mental health treatment they need, we get them the medication, we get them the treatment, we get them those resources, the rates of recidivism decrease dramatically. And so that is the goal of this.
Thank you, Your Honor. Thank you, Chair.
Thank you. Other questions from members of the committee? All right. I'm not seeing any. So we will move to testimony at this time. Thank you again for being here and answering our questions and presenting to us. We'll start with testimony in support of AB 405 in person in Carson City. I don't see anybody else in Las Vegas. So go ahead whenever you're ready in Carson City in person.
Good afternoon, Chair Scheibel, Vice Chair Harris, Committee. The LVMPD, I'm Adrian Hunt, ADRIAN-HUNT. I'm representing the Las Vegas Metropolitan Police Department. The Las Vegas Metropolitan Police Department is 100% in support of increasing access to mental health. We are committed to doing anything and everything to alleviate the mental health crisis. We want to thank Judge Wood for bringing this bill forward, and we support AB 405. Thank you.
Hello, Chair Scheibel. Elise Monroy-Marsala here today on behalf of two of our clients, the National Alliance for Mental Illness Nevada chapter and the Nevada Psychiatric Association. Nevada, I'm sure you've heard this year, it's hard not to hear, lacks a lot of the front-end services, treatment services and supports needed to help people with mental illness. So ensuring that there are programs in place to support people with intellectual disabilities or mental illness when they become involved with the justice system at whatever level that is something that NAMI absolutely supports. For many people, unfortunately, the easiest way for them to get linked to treatment is in the judicial system or the court system. Not only is that a horrible way to have to access treatment, that's incredibly expensive for our system. So not ideal, of course. So the only other thing I want to say is NAMI Nevada and the Nevada Psychiatric Association is here in the building really this session to support a lot of the infrastructure needed in our behavioral health system. This includes supported housing, crisis intervention, and expansion of the certified community behavioral health centers. But until Nevada has a better infrastructure for supporting people with mental illness, we have to continue to support efforts like this one that Judge Wood is putting forward to make sure that when people become involved with the criminal justice system, they are treated the most appropriate way for them. Please support this bill. Thank you.
Good afternoon, Chair Scheibel and members of this committee. I'm going to try to stay below my 2 minutes, but I might go to 2 minutes and 15 seconds. Okay, so my name is Catherine Nielsen. I'm the Executive Director of the Nevada Governor's Council on Developmental Disabilities. I want to remind you that individuals with intellectual and or developmental disabilities are at an increased risk of co-occurring disabilities with mental health conditions. Having an intellectual disability or mental health condition puts you at an increased risk for being involved in the criminal justice system as both victims and suspects more often than those without disabilities. Many studies have been conducted to show that the outcomes for offenders with intellectual disabilities and co-occurring disorders are significantly more likely to be negative compared to offenders without. This includes little access to support in the community and likelihood for reoffending and or being re-interviewed by the police within the first 10 weeks of release. Individuals with intellectual disabilities also constitute a small but nonetheless growing percentage of suspects and offenders within the criminal justice system. While those with intellectual disabilities comprise 2 to 3% of the general population, they represent 4 to 10% of prison populations, with an even greater number of those in the juvenile facilities and in jails. Research has found that fewer than 4.2% of current offenders have intellectual disabilities in Nevada. And some people with intellectual disabilities commit crimes not because they have below average intelligence, but because of their unique personal experiences, environmental influences, and individual differences. Almost all people with intellectual disabilities now live in the community and are susceptible to becoming involved in the criminal justice system as suspects or victims. And as suspects, people with disabilities are frequently used by other criminals to assist in law-breaking activities without understanding their involvement in a crime and or the consequences of their involvement. They may also have a strong need to be accepted and may agree to help with criminal activities in order to gain friendship. And many individuals unintentionally give misunderstood responses to officers, which increase their vulnerability to arrest, incarceration, and possibly execution if they have not even committed a crime. Considering such extreme disadvantages, it is not surprising that people with intellectual disabilities are more likely to be arrested, convicted, sentenced to prison, and victimized in prison. And once in the criminal justice system, these individuals are less likely to receive probation or parole and tend to serve longer sentences due to an inability to understand or adapt to prison rules. This bill is vital to ensuring that the courts have the abilities to address the needs of our most vulnerable offenders and that they can rehabilitate these offenders in our state, and thus reducing recidivism. Thank you for your time.
Good afternoon, Chair Scheibel, members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. We are in support of AB 405, and we'd like to thank Judge Wood for working with us to address any concerns that we had. This bill is a good step into ensuring that wherever people live in Nevada, they may have easier access to a mental health court or other specialty court program that can assist them in moving forward in their lives. Thank you.
Good afternoon, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office, testifying in support of AB 405 this afternoon. I heard a judge recently say we don't have a crime problem, we have a mental health problem in this country, and I think that's true. In the work that we do, most of our clients have some co-occurring disorder, and this is a very important step towards making sure that everyone who is in need of assistance and also in the criminal justice system is going to be able to actually access that help. So we urge your support. Thank you.
Thank you, Chair. John Puro from the Clark County Public Defender's Office. We are in support of this measure. We'd like to thank Judge Wood for bringing it forward, Jenny Noble from Washoe for helping us work out some of the kinks before it got over to this side. And this is a solid tool in the toolbox that will, one, provide treatment, two, prevent recidivism, and three, hopefully get people the services that we just do not provide before they come into contact with the criminal justice system. Thank you.
My name is Wes Getz. I was in your prison system for 10 years, and this sounds like a good bill, but I just want to make sure if these people are incarcerated in our prisons, to make sure that the psychologists that are in our prisons are licensed by the state. Because when I was in the prison system from 2000 to 2009, I find out that the psychologists there are not licensed by this state or any other state. And so if you have this kind of program, I prefer you to start licensing the psychologists that are working with the mental people in the prison system. Thanks.
All right, thank you everybody for your testimony in support of AB 405 in person. We'll now go to the phones for testimony in support of AB 405.
Thank you, Chair. We have no callers in support at this time.
All right, then we will go to testimony in opposition to AB 405. I don't see anybody coming forward in person, so we'll go to the phones for testimony in opposition to AB 405.
We have no callers to testify in opposition at this time.
Okay, then we will go to neutral testimony on AB 405. Anybody wishing to give neutral testimony? Don't see anybody in person, so we'll go to the phones.
We have no callers to testify in neutral at this time.
All right, then that brings us to the conclusion of testimony on AB 405. Unless the sponsors have any closing remarks or clarifications.
Hello, Chair. I'm sorry, very briefly, if I could.
Of course, go ahead.
I was just given the data, but thank you, Mr. McCormick. The recidivism study that we did on our specialty courts in 2018 showed we have a 91.8 success rate in terms of no new convictions within 3 years when we have an individual who goes through the specialty courts. So just to answer the recidivism question. And then the final remark that I did want to make, I just wanted to let the committee know, I previously thanked our stakeholders and community partners. We are working together on one potential proposed amendment, but I didn't want to propose it until I'd had a chance to speak with all of our stakeholders and community partners. And that is just, you may be receiving an amendment for Section 2 in regards to NRS 176A.255. Currently only gives the ability to transfer a case from justice court to district court, mental health court, if the justice court has not established a program. Some of our rural courts did have concerns because some of our more rural areas of our states don't have the same access to resources. So we did want to just add some language in there that if the courts found it appropriate, if somebody has something particularized that their local area couldn't treat them, then we would still be able to transfer that to the district court. But again, that won't be an amendment that'll be proposed unless we have all of our community stakeholders and partners on board.
All right, thank you. We appreciate that, and we will look forward to hearing from you again before as we continue to work on the bill. And with that, I will close the hearing on AB 405 and move on to public comment. If there's anybody wishing to give public comment in person, now is the time. But I don't see anybody coming up to the tables in Carson City or Las Vegas, so we will go to the phones, please, for public comment.
We have no callers to provide public comment at this time.
All right, then that brings us to the end of our meeting. We will be meeting here again, same time, same place tomorrow. And until then, we are adjourned.